Did you know that the severance agreement you signed may have included clauses that are now considered illegal? In 2023, the National Labor Relations Board made a major ruling that impacts what employers can and cannot include in severance agreements. If you're an employee or an HR professional, stay tuned because you will want to know about this. Hi, I'm Harlow Reed. Welcome to the HR Insider. Today we're talking about what changed with severance agreements, why it matters, and what you should consider before signing a severance package. Let's talk about it. The content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. Always consult a qualified attorney or HR professional for specific guidance tailored to your needs. Thank you so much for liking this video, making a comment, and subscribing to this channel. Let's start with the basics. A severance agreement is a legal contract between an employer and an employee that typically offers the employee a lump sum payment or other benefits in exchange for certain conditions. Those conditions include, but are not limited to, not suing the company, keeping quiet about what happened at work, or agreeing not to speak negatively about the employer. Sounds straightforward, right? But these agreements often include more than just a paycheck. They come with strings attached, like confidentiality clauses that prevent you from talking about what happened at work, or non-disparagement clauses that stop you from criticizing your employer. Here's the thing. Many of those clauses are now illegal for certain employees under the latest NLRB ruling. The NLRB found that these broad clauses that prevented employees from discussing their severance terms or speaking negatively about their employer were a violation of employees' Section 7 rights under the National Labor Relations Act. So, exactly what are Section 7 rights? Well, these are the rights that employees have to talk about their wages, to talk about working conditions, and any workplace issues with their coworkers. This allows them to engage in collective bargaining and begin the process for discussing union organizing or putting them in a position where they can collaborate together for better working conditions. Let's break down the types of clauses that are now problematic. First, confidentiality clauses. These clauses used to prevent employees from discussing the terms of their severance agreements with coworkers, family, or even the media. Now, the National Labor Relations Board says that's illegal. The second type of clause that is problematic is non-disparagement clauses. These are the clauses that employers used to include broad non-disparagement clauses that said you can't say anything negative about the company. But now that's also illegal unless it's very narrowly tailored. For example, an employer can still ask you not to make maliciously false statements about them, but they can't stop you from making a statement that implies or explicitly states that you had a bad experience at work. Now, the question of this video is, are severance agreements illegal? Well, no, they're not. Employers can still include clauses about trade secrets and proprietary information, and they can still include non-disparagement clauses, but only if they're very specific and don't interfere with an employee's Section 7 rights. A key tip for employees, if you receive one of these severance agreements, is not to sign it right away and to take time to read the fine print and, if possible, get legal advice. Advice from another professional who can assist you with understanding what the conditions that are being placed on you by signing the agreement. So, why does this matter for you? Well, the National Labor Relations Board ruling could actually deter employers from offering severance to employees altogether. The purpose of severance agreements has always been to give employees a soft landing after a job loss, helping them during a time of transition, figuring out where they're going, as well as processing where they have been and what has actually happened to them as a result of a layoff. It also helps employers avoid the costs of litigation that is associated with termination. So, the stricter rules around confidentiality and non disparagement may lead some companies to reconsider whether offering severance is worth the risk. It also means that if you are an employee who is laid off, you actually have more leverage than you did before because of these stricter rules. Now, many severance agreements from the past may have included some of these clauses, which make the agreements which can nullify the terms of the agreement. So, if your agreement has a broad confidentiality or non disparagement clause, it's worth asking, is this even enforceable? The NLRB is really focused on confidentiality and disparaging remarks, but please be mindful that severance agreements also have many more conditions in addition to the two that are the primary focus by the National Labor Relations Board. HR professionals out there have to know that this is a really big deal. It's a really big deal for employers, especially those who are planning layoffs in 2025, making sure that they review and revise severance agreements so that they are compliant with this new ruling is going to be very, very important. If you don't, your company could face legal challenges down the road. Three things to remember from this video. Number one, if you're offered a severance package, read it carefully. Get legal counsel if you can afford it. If not, read it carefully before you sign it. Number two, confidentiality and non disparagement clauses may no longer be enforceable. So even if it's in your agreement, that part of your agreement is not enforceable. And as a matter of fact, it could potentially nullify the entire agreement. So please be aware that confidentiality and non disparagement clauses should no longer be included in your severance agreement. And the final thing is you have the right to speak about workplace conditions even after you leave. If you want to talk about what your experience was like in the workplace, you have a legal right to do so. Thanks for watching today's episode of the HR Insider. If you found this video helpful, please be sure to like, subscribe, and hit the bell icon so you don't miss future updates. And remember, workplace fairness starts with accountability. I'll see you in the next video.